Due process extends to three important areas in the study of criminal justice, and those areas are search and seizure, arrest, and interrogation, and comes from the Fifth Amendment, is the amendment that guarantees us the right to due process. So first we will look at search and seizure. So people are protected against unreasonable searches and seizures. So reasonable search would be one where an officer has probable cause and either it's something that was committed in their presence or they have a search warrant. Unreasonable would be I'm sitting in my house at 11 o'clock at night. I assume that the police aren't just going to barge in and search my house if they don't have a search warrant, because that would be unreasonable. We'll look at three different cases. The 1914 case of Weeks versus United States said that illegally seized evidence can't be used in court. So if the police illegally search someone's home, they can't expect to be able to use that evidence that they find in court as they're prosecuting the person for whatever the illegal charge is. Second, there was the 1920 case of Silverthorne Lumber Company versus United States. And just as illegally seized evidence can't be used, neither can evidence that's derived from an illegal search or seizure. So for an example, let's say that police officers conduct an illegal search of Jim's home. During that search, they find illegal drugs, and they also find evidence that proves that Brittany is selling drugs from her home next door. The officers apply for and obtain a warrant for Brittany's home. The exclusionary rule prevents the police from using information obtained during a legal search to gain access to legally search another area. Now, that doesn't mean that they can't perform surveillance and other investigatory measures to be able to go apply for a search warrant legally for Brittany's house. So basically, any evidence that is derived from an illegal search can't be used in court. And then in 1961, which is 47 years later, Mapp versus Ohio was decided, and that applied the exclusionary rule to the state courts. So in Weeks versus United States, the exclusionary rule was only binding to federal agents, and in Mapp versus Ohio, the exclusionary rule was extended to the states. The next area that we look at is an arrest. And an arrest occurs when a law enforcement officer restricts a person's freedom to leave. Now, traffic stops do not meet this test because they're merely detentions, because most reasonable people, I'll say, would know that when they are pulled over by the police for a simple traffic violation, they will be free to leave just as soon as the officer finishes up with the traffic stop. If a person is arrested, assuming there is probable cause to do so, the police officer can search the immediate area surrounding the person. Now, this differs from an investigatory stop, where if police perform an investigatory stop based on reasonable suspicion, that is less than probable cause. They are allowed to perform a Terry frisk, where they pat down the outer clothing of the suspect to ensure that the person isn't carrying any weapons. And the last one that we look at is interrogation. So the Supreme Court has ruled that interrogation is any behavior by the police that the police should know are reasonably likely to elicit an incriminating response from the suspect. This differs from an interview, where an interview is fact gathering, and interrogation is where they are trying to get direct information about a crime from the person that they think probably did it or was involved in it or had knowledge of it. And it has more of an accusatory tone. During an interrogation, the police are not allowed to resort to physical abuse, coercion, or psychological manipulation. And during an interrogation, police are required to warn the suspect of their Miranda warnings. So they have the right to an attorney during the interrogation. Now, the suspect can waive these rights and speak with the police anyway. The police would document that in writing and get the suspect's signature. If the suspect waives their rights and agrees to talk to the officer, he or she can revoke that at any time and request a lawyer during the questioning. Now, if they do that in the middle of an interrogation, all questioning must stop. The police have to leave that person alone until the suspect's attorney is present. So I hope this gives you a better understanding of due process and how it extends to the three areas of search and seizure, arrest, and interrogation.